Welcome to PrepPass. Here are 50 real California security guard card practice questions with answers for 2026. Read each question, then try to answer before the 5-second timer runs out. For the full free practice test, just search preppass.org. Let's begin. Question 1. Under California Penal Code Section 835, an arrest is made by which of the following? A. Verbally informing the person they are under arrest. B. An actual restraint of the person, or by submission to the custody of an officer. C. Calling the police to the scene. D. Identifying the suspect to a witness. The correct answer is B. Penal Code Section 835 defines an arrest as being made by an actual restraint of the person, or by submission to the custody of an officer. The person arrested may be subjected to such restraint as is reasonable for the arrest and detention. Question 2. A private security guard takes a shoplifter into custody. Under Section 835, what level of restraint may the guard use? A. Whatever force is necessary to ensure no escape, regardless of severity. B. Only handcuffs, any other restraint is unlawful. C. Such restraint as is reasonable for the arrest and detention. D. No physical restraint at all. The correct answer is C. Penal Code Section 835 expressly allows that the arrestee may be subjected to such restraint as is reasonable for his arrest and detention. Excessive or punitive restraint exceeds this authority and exposes the guard to civil and criminal liability. Question 3. An unarmed suspect, without being touched, hears the guard say "You are under arrest" and stops, putting hands behind back. Has an arrest occurred under Section 835? A. No, no physical contact has occurred. B. No, only a sworn peace officer can effect an arrest. C. Yes, submission to custody satisfies Section 835. D. Yes, but only if the suspect signs an acknowledgement. The correct answer is C. Penal Code Section 835 lists submission to the custody of an officer as one of the two ways an arrest is made. Physical restraint is not required where the arrestee voluntarily submits. Question 4. Which arrest authority does Section 836 grant peace officers that is broader than the authority Section 837 grants private persons? A. Authority to use a baton during arrest. B. Authority to arrest for a felony based on reasonable cause, even where no felony was in fact committed. C. Authority to write incident reports. D. Authority to carry a firearm on duty. The correct answer is B. Penal Code Section 836A allows a peace officer to arrest on probable cause that a felony was committed, with significant protection from civil liability even if it later turns out no felony actually occurred. Question 5. 2 minutes ago, a witness reported seeing someone slap another person inside the store. The suspect is still nearby in the parking lot. Under Section 837, may the guard arrest the suspect for the misdemeanor battery? A. Yes, battery is always arrestable on probable cause. B. Yes, the witness report constitutes presence. C. No, for misdemeanors, the offense must be committed in the private person's actual presence. D. No, only peace officers may arrest for any offense. The correct answer is C. Penal Code Section 837(1) authorizes a private person arrest for a public offense committed or attempted in his presence. A witness report of a misdemeanor that occurred outside the guard's actual perception does not satisfy that requirement. Question 6. Reasonable cause under Section 837 means which of the following? A. Mere suspicion based on appearance or hunch. B. A proof beyond a reasonable doubt, the criminal trial standard. C. Facts that would lead a person of ordinary care and prudence to entertain an honest and strong suspicion that the person is guilty. D. Whatever the security officer subjectively feels at the time. The correct answer is C. The reasonable cause, often called probable cause, standard from People v. Question 7. A security guard personally witnesses an armed robbery in progress at the store. Under Section 837, the guard may A. Only call 911. Private persons have no arrest authority during armed offenses. B. Arrest the suspect for the felony, applying reasonable force, and deliver without unnecessary delay to police. C. Arrest only after the suspect drops the weapon. D. Arrest only with prior written authorization from BSAS. The correct answer is B. Penal Code Section 837(1) allows a private person to arrest for any public offense, including a felony, committed or attempted in his presence. Armed robbery is a felony, PC Sections 211, 212.5. Question 8. After a lawful private person arrest, Penal Code Section 847 requires the private person to A. Hold the arrestee until they confess to the offense. B. Take the arrestee before a magistrate, or deliver them to a peace officer, without unnecessary delay. C. Process the arrestee through the security company's office first. D. Release the arrestee if they apologize and promise not to return. The correct answer is B. Penal Code Section 847(a) requires a private person who has arrested another without unnecessary delay, take the person arrested before a magistrate, or deliver him or her to a peace officer. Delay beyond what is reasonably necessary may invalidate the arrest and exposes the guard to false imprisonment civil claims. Question 9. A security guard sees a person acting suspiciously near merchandise but has not seen a theft. The guard approaches and asks the person to stop and speak briefly. This encounter is best characterized as A. An arrest under Section 835, any approach constitutes restraint. B. A consensual encounter, no detention has occurred unless a reasonable person would not feel free to leave. C. An automatic violation of the suspect's rights. D. A search under the Fourth Amendment. The correct answer is B. California recognizes 3 levels of encounter. 1. Consensual contact, no restraint, no justification required. 2. Detention, temporary restraint requiring reasonable suspicion of criminal activity. 3. Arrest, full custody requiring reasonable/probable cause. Question 10. When making a private person arrest, what does Penal Code Section 841 generally require the arrestor to do? A. Nothing, only peace officers must identify themselves and state the cause. B. Give Miranda warnings before any questioning. C. Inform the person of the intention to arrest, the cause of the arrest, and the authority to make it. D. Obtain the suspect's written consent before restraint. The correct answer is C. Penal Code Section 841 generally requires the person making an arrest, peace officer or private person, to inform the arrestee of the intention to arrest, the cause of the arrest, and the authority making it. Question 11. Under Section 841, when may notification of authority to arrest be omitted? A. Whenever notification is inconvenient. B. Never, the notification is absolute. C. When the person is actively engaged in commission of the offense, is in flight, or notice would imperil the arrest. D. Only with a court order authorizing the omission. The correct answer is C. Penal Code Section 841 itself recognizes that notice need not be given when the person to be arrested is actually engaged in commission of an offense, is in flight after commission, or where giving notice would be impractical because of intended use of force by the suspect. Question 12. A security guard effects a lawful citizen's arrest. The suspect resists. What force standard applies to the private person? A deadly force is automatically authorized once the suspect resists. B. A reasonable force, proportional to the resistance and only that necessary to effect and maintain the arrest. C. No force at all, the guard must release the suspect when resistance begins. D. The same broad use of force protections peace officers receive under Section 835A. The correct answer is B. A private person making a lawful arrest may use reasonable force necessary to effect and maintain the arrest, consistent with Section 835's restraint authority and common law tort principles. Question 13. After a lawful private person arrest, may a security guard search the arrestee? A. Yes, a full inventory search like a peace officer's search incident to arrest. B. A limited search for weapons, officer safety, and to prevent destruction of evidence, pending arrival of police. C. Yes, including a strip search if the guard reasonably suspects concealed items. D. No, any search by a private person is unlawful. The correct answer is B. A private security guard's authority to search incident to a citizen's arrest is narrower than a peace officer's. Question 14. Under Section 490.5 F, a detention under the shopkeeper's privilege must be A. For up to 24 hours, regardless of circumstances. B. Reasonable in manner and time, generally only that needed to investigate ownership of the merchandise and await a peace officer. C. Accompanied by mandatory handcuffing in every case. D. Conducted in the store parking lot, never inside the store. The correct answer is B. Penal Code Section 490.5 F. 3. Permits detention in a reasonable manner and for a reasonable time to investigate ownership, request that a peace officer take custody, and surrender the person to the officer. Question 15. Penal Code Section 490.5 F. Requires what level of belief before a merchant or merchant's agent may detain a suspected shoplifter? A. Mere suspicion based on the person's appearance. B. Probable cause to believe the person unlawfully took merchandise from the premises. C. Eyewitness video evidence of the taking. D. The suspect's confession before any detention. The correct answer is B. Penal Code Section 490.5 F. 2. Requires the merchant or merchant's agent to have probable cause to believe the person to be detained was attempting to unlawfully take or has unlawfully taken merchandise from the premises. Mere suspicion, A, is insufficient and exposes the guard to false imprisonment liability. Question 16. Penal Code Section 849B lists circumstances in which a peace officer may release a person arrested without taking them before a magistrate. Which is not one of those grounds? A. The arrestee promises not to commit the same offense again. B. The officer is satisfied there are insufficient grounds for a criminal complaint. C. The person was arrested only for intoxication and no further proceedings are desirable. D. The person was arrested only for being under the influence of a controlled substance and is delivered to a treatment facility. The correct answer is A. Penal Code Section 849B lists 3 statutory grounds for officer release. 1. Insufficient grounds for a criminal complaint. 2. Arrest for intoxication only with no further proceedings desirable. And 3. Arrest for being under the influence of a controlled substance only, with delivery to a county treatment facility. Question 17. When a peace officer releases an arrestee under Section 849B, 1. Insufficient grounds, Penal Code Section 849.5 treats the incident as a detention only, not an arrest, for all official records. b. An arrest that must remain on the person's criminal history. c. A conviction unless successfully expunged. d. A felony stop regardless of the underlying offense. The correct answer is A. Penal Code Section 849.5 expressly provides that when a person is arrested and released under Section 849(b)(1), the arrest shall be deemed a detention only. This protects the released person from carrying an arrest record where the officer concluded there was insufficient basis to proceed. Question 18. Penal Code Section 835 limits the restraint authority of any person making an arrest. The standard is A. Such restraint only as is reasonable for the arrest and detention. B. Whatever force the arrestor believes necessary, in good faith. C. Maximum force consistent with officer safety. D. A force that matches or exceeds the suspect's resistance. The correct answer is A. Penal Code Section 835 states that the person arrested may be subjected to such restraint as is reasonable for his arrest and detention. Reasonableness is judged objectively from the totality of circumstances and is independent of the arrestor's subjective intent. B. Question 19. A BSES registered guard card holder wishes to carry a concealed firearm while on duty. Beyond the basic guard card, what additional credential is required? A. An additional 8-hour training session only. B. A criminal justice degree. C. A peace officer sponsorship. D. A separate BSES firearms permit under BPC Section 7583.12, including additional firearms training, qualification, and background. The correct answer is D. A standard guard card permits unarmed security duty only. Question 20. A BSES licensed guard wishes to carry a baton on duty. The legal prerequisite is A. Verbal authorization from the security company's supervisor only. B. A separate BSES baton permit under BPC Section 7585.10, requiring completion of a state-approved baton training course. C. A college course in martial arts. D. Membership in the National Association of Security Guards. The correct answer is B. Business and Professions Code Section 7585.10 and related BSES regulations requires a separate baton permit to carry a baton in performance of guard duties. The applicant must complete a BSES-approved baton training course taught by a certified instructor. Question 21. Penal Code Section 853.6, Release on citation for misdemeanors. Authority belongs to A. Peace officers, not private security guards. B. Any person making a citizen's arrest. C. BSES licensed guards with 5+ years of service. D. As security supervisors who hold a notary commission. The correct answer is A. Penal Code Section 853.6 allows a peace officer to release a person arrested for a misdemeanor on a written promise to appear, in lieu of taking the person before a magistrate. The authority is statutorily limited to peace officers. Question 22. Business and Professions Code Section 7583.39 holds the licensee, security company, responsible for which of the following conduct by an employee guard? A. Only conduct authorized in advance and in writing by the licensee. B. Only criminal conduct, never civil torts. C. Only conduct during paid hours, never off-duty. D. Conduct of the employee acting within the scope of employment, creating vicarious liability for the security company. The correct answer is D. BPC Section 7583.39 and California vicarious liability principles, including respondeat superior under Civil Code Section 2338 and case law, make the security licensee responsible for acts of employees within the scope of employment. Question 23. Under SB 652, effective January 1, 2026, the 8-hour power to arrest and appropriate use of force course must now be A. Split across 2 providers, 4 hours each, freely chosen. B. Administered and certified by a single BSAS licensed training provider, with proof of completion presented to BSAS. C. Completed online with no in-person component. D. Self-certified by the applicant. The correct answer is B. SB 652 amended the BSAS training scheme to require the 8-hour power to arrest and appropriate use of force course be administered and certified by a single BSAS licensed training provider. Question 24. Under SB 652, the 8-hour power to arrest and appropriate use of force course must be completed within what time window before submitting the guard card application? A. 12 months. B. 2 years. C. No time limit. D. is 6 months. The correct answer is D. SB 652 imposes a 6-month freshness requirement. The 8-hour power to arrest and appropriate use of force course must be completed within 6 months before the guard card application is submitted to BSAS. Question 25. Under 16 CCR Section 628, BSAS training regulations, the passing standard for the power to arrest and appropriate use of force course final exam is A. 70%. B. 100% retakes are permitted. C. 80%. D. Passing is at instructor discretion. The correct answer is B. 16 CCR Section 628 requires a 100% score on the power to arrest and appropriate use of force course final exam. Retakes are permitted. Applicants who do not pass on the first attempt may retake until they pass. Question 26. If a peace officer uses unnecessary force on a person under color of authority, Penal Code Section 149 provides A. Criminal liability for the officer, punishable as a misdemeanor or, when great bodily injury occurs, a felony. B. is civil damages only, no criminal exposure. C. Automatic loss of peace officer certification but no criminal charge. D. nothing. Section 149 was repealed. The correct answer is A. Penal Code Section 149 makes it a public offense crime for a peace officer to assault or beat a person under color of authority without lawful necessity. Question 27. Penal Code Section 834 defines an arrest as A. a formal court appearance. B. booking at a county jail. C. the filing of a criminal complaint. D. the taking of a person into custody, in a case and in the manner authorized by law. The correct answer is D. Penal Code Section 834 defines an arrest as the taking of a person into custody, in a case and in the manner authorized by law. It may be made by a peace officer or by a private person under the relevant authority statutes. Question 28. Penal Code Section 834A provides that if a person has reasonable cause to believe they are being lawfully arrested by a peace officer, they A. may resist if they believe the arrest is unjustified. B. have a duty to refrain from using force or weapons to resist the arrest. C. may flee but not strike the officer. D. may resist with reasonable force only. The correct answer is B. Penal Code Section 834A expressly states that if a person has knowledge, or by exercise of reasonable care should have knowledge, that they are being arrested by a peace officer, It is the duty of such person to refrain from using force or any weapon to resist such arrest. The statute applies to peace officer arrests. Common law rules historically allowed reasonable resistance to plainly unlawful arrests, but Section 834A sharply curtails that for peace officer arrests. Question 29. If a person resists, delays, or obstructs a peace officer in the discharge of duty, Penal Code Section 148A(1) makes the conduct a civil infraction with a $50 fine. B. Always a felony. C. A federal offense exclusively. D. A misdemeanor. The correct answer is D. Penal Code Section 148A(1) makes it a misdemeanor to willfully resist, delay, or obstruct a peace officer, or EMT, in the discharge of duty, punishable by up to 1 year in county jail and/or fine. The offense covers a broad spectrum of conduct. Question 30. Penal Code Section 835A, as amended by AB 392, 2019, declares that the authority to use physical force is a serious responsibility to be exercised, a. aggressively to maintain authority. B. Whenever any law is violated. C. Judiciously, with the highest regard for the dignity and sanctity of every human life. D. Only by sworn supervisors. The correct answer is C. Penal Code Section 835A(1) reflects the legislative findings of AB 392, declaring that the authority to use physical force, conferred on peace officers by this section, is a serious responsibility that shall be exercised judiciously and with the highest regard for the dignity and sanctity of every human life. Subsequent provisions emphasize de-escalation, alternatives to force, and limit deadly force to imminent threats. Question 31. Penal Code Section 835A(2), consistent with SB 230's training mandate, requires officers to a. use de-escalation techniques, crisis intervention tactics, and other alternatives to force when feasible. B. Use force as the first option to maintain control. C. Always wait for backup before any contact. D. Avoid all verbal contact with non-compliant subjects. The correct answer is A. Penal Code Section 835A(2) embodies California's de-escalation policy. Officers should use de-escalation techniques, crisis intervention tactics, and other alternatives to force, when feasible. SB 230 reinforces this with state-mandated training. Question 32. Penal Code Section 692 provides that lawful resistance to the commission of a public offense may be made by a. the party about to be injured, or by other parties. B. Only by sworn peace officers. C. Only by licensed security personnel. D. Only after a verbal warning is ignored. The correct answer is A. Penal Code Section 692 states lawful resistance to a public offense may be made by 1. the party about to be injured, 2. other parties. This is the statutory foundation for self-defense and defense of others in California. Question 33. On the force continuum, a security guard should escalate force based on a. the level of resistance and threat presented, applying only the minimum reasonable force necessary to control the situation. B. The number of bystanders present. C. The arrestee's apparent socioeconomic status. D. The political pressure on the security company. The correct answer is A. Reasonableness and proportionality govern force decisions. Question 34. Once an arrestee is fully restrained, e.g., handcuffed and seated, no longer resisting, further use of force by the guard is a. generally not permitted. Additional force becomes excessive and may constitute battery, Section 242, or assault, Section 240. B. Permitted as pain compliance to reinforce control. C. Required as a deterrent against future resistance. D. Permitted at the guard's discretion until police arrive. The correct answer is A. The reasonableness analysis under Section 835 and Graham v. Connor terminates at the point necessary force ends. Question 35. Penal Code Section 236 defines false imprisonment as the unlawful violation of the personal liberty of another. Which of the following is the most accurate civil liability description for a security guard? A. Only intentional detention beyond 24 hours is actionable. B. Liability only attaches if the detainee was physically harmed. C. Any intentional, non-consensual confinement without lawful authority is actionable, regardless of duration or harm. D. False imprisonment requires the use of handcuffs or other physical restraint. The correct answer is C. False imprisonment is the unlawful violation of personal liberty, PC Section 236, and is also a tort under Civil Code Section 43, which protects personal liberty. Question 36. Under Penal Code Section 237, false imprisonment is punishable as a felony when it is effected by A. Violence, menace, fraud, or deceit. B. Asking the suspect to remain seated. C. Locking a store door for a routine end-of-day procedure. D. Use of a uniform and badge during normal patrol. The correct answer is A. Penal Code Section 237, B. Elevates false imprisonment to a felony affected by violence, menace, fraud, or deceit, punishable by 16 months, 2 or 3 years in state prison. Question 37. Penal Code Section 242 defines battery as any willful and unlawful use of force or violence upon the person of another. Which of the following best describes the standard for security guards? A. Battery requires actual physical injury before liability attaches. B. A battery requires the use of a weapon or instrument. C. Even the slightest unlawful touching done willfully is battery. The touching need not cause pain or injury. D. A battery applies only when the touching occurs on bare skin. The correct answer is C. Battery under PC Section 242 is any willful and unlawful use of force or violence upon the person of another. California Courts, People v. Question 38. Penal Code Section 240 defines assault as an unlawful attempt, coupled with presentability, to commit a violent injury on another person. For a guard, which scenario most clearly meets all assault elements? A. Raising a baton overhead within striking distance of a compliant suspect who is not resisting. B. Verbally warning a suspect that they will be arrested if they do not leave. C. Holding a baton at the ready position during a peaceful escort. D. Pointing toward a parking lot exit while asking a person to leave. The correct answer is A. Assault under PC Section 240 requires 1. An unlawful attempt, 2. Coupled with presentability, 3. To commit a violent injury. Question 39. What is the statute of limitations for civil false imprisonment and battery claims against a security guard in California? A. 30 days from the incident. B. 6 months from the incident. C. 10 years, the catch-all period. D. 1 year from the date the cause of action accrued, under CCP Section 340, C. The correct answer is D. CCP Section 340, D, sets a 1-year statute of limitations for assault, battery, false imprisonment, and other intentional torts against the person. The clock generally runs from the date the cause of action accrues, typically the date of the wrongful act. Question 40. Which combination identifies the elements of a negligence claim against a security guard or PPO? A. Intent, malice, harm, motive. B. Knowledge, planning, execution, profit. C. Contract, breach, consideration, performance. D. A duty, breach, causation, actual and proximate, and damages. The correct answer is D. California negligence has 4 elements. 1. A legal duty owed to the plaintiff. 2. Breach, failure to conform to the applicable standard of care. 3. Causation, both actual, but 4. Cause and proximate, legal, cause. And 4. Actual damages. Question 41. The 5 W's and H framework for incident reports captures A. Words, weight, wisdom, wages, work, height. B. Who, what, when, where, why, and how, the core facts every incident report should establish. C. Where the guard slept, what was eaten, when shifts ended, why call-outs occurred, how many breaks, what wages. D. Withdrawals, weather, witnesses, work hours, write-ups, holidays. The correct answer is B. The 5 W's plus H is the Universal Investigative and Reporting Framework. Who, identities, victim, suspect, witnesses, responders, what, the incident, facts in sequence, when, date and time of each material event, where, precise location, including landmarks, why, motive or apparent reason, were supportable by evidence, and how, means and manner. Question 42. When organizing the body of an incident report describing a sequence of events, the most generally preferred structure is A. Chronological, events in the order they occurred, with precise times. B. Alphabetical by witness last name. C. By report writer's emotional response. D. By severity of each event, most severe first. The correct answer is A. Chronological structure is the standard for narrative incident reports because it tracks the natural flow of events, makes timelines unambiguous, simplifies cross-referencing with video and witness statements, and resists confusion during cross-examination. Question 43. The BSES curriculum emphasizes that the security guard is often the first representative of the client a visitor encounters. The most appropriate mindset for routine interactions is A. Customer service-oriented, greet, assist, and direct visitors while remaining alert. B. Adversarial, assume every visitor is a potential threat. C. Minimal contact, avoid speaking to visitors unless required. D. Strictly authoritarian, issue commands rather than questions. The correct answer is A. The BSES power to arrest manual stresses that security officers serve as ambassadors for the contracting client. Question 44. In a verbal confrontation, the security officer should generally maintain what interpersonal distance to reduce perceived threat while preserving reaction time? A. Within 18 inches, intimate distance, to read microexpressions. B. Touching distance, to physically intervene if needed. C. 20 feet or more, yelling distance, to avoid any contact. D. Approximately 4 to 6 feet, social distance, allowing reaction space and reducing threat cues. The correct answer is D. Edward Hall's proxemics framework, taught in BSES de-escalation modules, identifies social distance, roughly 4 to 12 feet, as appropriate for professional interactions. Question 45. Which question is open-ended and best suited to gathering an account from a witness? A. Can you describe what you saw, in your own words? B. Did the man have a knife? C. Was the car blue? D. Are you sure it happened at 9 p.m.? The correct answer is A. Open-ended questions invite a narrative response and reduce the risk of leading the witness. Describe what you saw. A. Yields information the officer might not have known to ask about. Question 46. An officer responds to a complaint from an upset tenant. The most effective active listening technique is A. Paraphrase the tenant's concerns back, so what you're saying is, to confirm understanding. B. Interrupt to correct factual errors as soon as they arise. C. Take silent notes without verbal acknowledgement. D. Quickly explain the policy that prevents action on the complaint. The correct answer is A. Active listening, paraphrasing, summarizing, and reflecting feelings, signals that the officer understands the complainant and reduces the emotional charge of the encounter. Question 47. When interpreting body language for signs of deception or aggression, the BSIS curriculum cautions officers to A. Treat any single indicator, sweating, lack of eye contact, as proof of deception. B. Rely on cultural stereotypes about who is more likely to lie. C. Use polygraph-style accusatory questioning to confirm suspicions. D. Look for clusters of indicators rather than single signals, and account for cultural and medical factors. The correct answer is D. Modern body language and deception research, including Paul Ekman's work, emphasizes that single signals, eye contact, fidgeting, sweating, have high false positive rates and may reflect cultural norms, neurodivergence, anxiety, medical conditions, or simple discomfort with authority. Question 48. Which of the following is not typically classified as a communication barrier addressed in BSIS training? A. Background noise on a busy retail floor. B. Limited English proficiency of the speaker. C. Strong emotion, fear, anger, at the time of the encounter. D. The officer's BSIS guard card registration number. The correct answer is D. Common communication barriers covered by BSIS training include physical noise, language differences, limited English proficiency, emotional state, perceived status or authority differences, sensory disabilities, and cognitive impairment. Question 49. A well-written security incident report should be characterized primarily by A. Clarity, brevity, and factual accuracy, written so a stranger reading later understands what happened. B. Vivid adjectives and emotional language to convey the seriousness of the incident. C. Legal conclusions about whether the suspect committed a crime. D. The author's personal opinions about the parties involved. The correct answer is A. BSIS report writing standards emphasize clarity, brevity, and accuracy. Reports must convey who, what, when, where, why, if known, and how, using neutral observable facts rather than conclusions or opinions. Question 50. California is one of the most linguistically diverse states. When interacting with a limited English proficiency (LEP) individual, an officer should A. Use simple vocabulary, gestures, and any available translation tools or interpreters. Avoid using minor children as interpreters. B. Speak more loudly and slowly using the same English vocabulary. C. Refuse to communicate until the person learns English. D. Assume any LEP speaker is undocumented and notify immigration authorities. The correct answer is A. Best practice for LEP interactions, reinforced by California's Demilitary Bilingual Services Act and federal civil rights principles, is to use simple vocabulary, visual cues, professional translation services, or bilingual coworkers, not to rely on minor children, which is discouraged because of confidentiality and developmental concerns. That's all 50 questions. Want the full guard card practice test with hundreds of questions, completely free? Just search PrepPass.org. Good luck on your exam.